All right, welcome to the 294th District Court. My name is Judge Chris Martin. I am going to call this morning's docket. When I call your name, please say present or here and raise your hand. Marvin Anderson. Kevin Collins. Michael Davis. Michael Edward Davis. Wayne Dean. Christopher Goins. Terry Ann Johnson. I believe Mr. Johnson is outside. Jaime Murillo Barrientos. Jaime Murillo Barrientos. Denetric Porter. Jason Bearden. Kenneth Nash. Eric Sperling. Eric Glenn Sperling. Joshua Ibarra. Joshua Andrew Ibarra. John Piercefield. Lonnie Richardson. Lonnie Jean Richardson. Eric Rodriguez. Braxton Henderson. Thank you, Mr. Sharp. John Chadwick. Here. Mitchell Gilbert. Mitchell Centel Gilbert. Tammy Caldwell. John William Lejean. I was thinking about it and I was working on it. Lejean, thank you, sir. Michael Lobb. Yes. Lenaria Miles. Brianna Podorf. Brittany Turner. Sergio Villarreal. Sergio Arturo Villarreal. Anna Hampton. Council President. Thank you, Mr. Rush. Nicholas Dubberly.
Mr. Dudley, he's having some transportation issues this morning. He's on the way.
Thanks, sir. For the record, Carlos Hernandez, waiver of arraignment filed, approved, pretrial set August 23rd. Emily Gayton. Trent Gonzalez. Here. Stephen Slayton. Dalton Thomas. Here. All right, council, do we have anyone that's ready? Agreed? Usually going to take a little bit some time, so to recall you. Do we have anyone else that's spoken with the state? Ready? Take that as a resounding no. All right. Marvin Anderson. Come on up, Mr. Anderson. All right, Mr. Anderson, you are set for arraignment today on possession of a controlled substance, penalty group 1 gram to 4 grams at 3rd degree felony. Mr. Anderson, are you going to represent yourself? Are you going to hire an attorney? Are you requesting court appointed attorney?
Court appointed.
You filled out the paperwork? All right, have a seat and I'll recall you back up. Ms. Payne, did you say you're ready?
Well, I have spoken with the state, I'm sorry, I stood up. I've spoken with the state, I filed this case yesterday, but I haven't, I want to go ahead and rate my client. Like, process.
Wayne Dean, CR 22-200. Mr. Dean, right over there, Payne, right behind this podium, towards your client's gonna go. Right, this is CR 22-200 State versus Wayne Dylan Dean. Mr. Dean is set for arraignment today. Ms. Payne, are you ready for arraignment?
We are, Your Honor.
Go ahead.
At this time, my client enters a plea of not guilty, though I would say we have not had a chance to go over the indictment. If Your Honor, does Your Honor have a copy?
Sure, the clerk does.
Okay, if we could reset, for either pretrial or just a docket call.
Well, I'd like to arraign him today, but he needs to go over the indictment so we can fix his identity, make sure his name's spelled correctly, make sure he understands what he's charged with, and then enter his plea. So how about I recall the case in a few minutes? Maybe the state would oblige you and get a copy. If not, you can go across the hall to the district clerk's office.
I'll step across the hall. My apologies.
Yes.
Your Honor, we're ready to make announcement on CR 21-289, Braxton Henderson.
All right. Mr. Henderson is set for pretrial. Mr. Strada.
Yes, Your Honor. Judge, our announcement is at the last pretrial that we had, we were asking for time for Southwest Institute of Forensic Science to comply with our subpoena. They have since complied with it. The contents are 2,400 pages approximately that have been submitted to my toxicologist for review. In addition, at our last pretrial, the court granted the transcription for limited purposes of an interview that was conducted at the CAC interview. We have since contracted a court reporter that's going to be transcribing the contents at the district attorney's office tomorrow at 9 a.m. Judge, I'd ask the court for some time to allow us to receive those items and allow our toxicologist to generate a report that I'd be sharing with the state. Without these items, we haven't had an opportunity to engage in meaningful plea negotiation. I think once we do have these items, we can sit and visit with the state in effort to attempt to reach some type of common ground in this matter.
Steve.
Your Honor, state's in full agreement. We are going to make our conference room available tomorrow and provide the CAC so that transcription can take place.
Okay, court will reset Mr. Henderson for an additional pretrial hearing. You available on August 23rd, Mr. Estrada?
Judge, what is the very next pretrial after that?
After that would be September.
What day in September, Your Honor?
Well, I'm not sure I want to go out to September. Is it going to take 60 days to get the toxicology report and then just, because pretrial is just going to be bringing up any of the pretrial issues and then filing any contested pretrial motions. I mean, there's going to be settings after that. But I don't know
August
if I'll-
23rd should work then, Judge.
All right, court's going to set Mr. Henderson for an additional pretrial on August 23rd. That will be at 9 a.m. And the court is going to order Mr. Henderson to submit to a UA and hair follicle today. So once you sign and get the yellow copy, come over here and have a seat. Mr. Waddell will be with you. Okay? And then Mr. Waddell. All right, so Mr. Henderson, once you sign, get the yellow copy, see Mr. Waddell, and he'll give you further instructions.
Yes, sir.
Mr. Manning, you ready? Mr. Easton, are you agreed with the state or are we putting on evidence today?
Maybe a short testimony, because we didn't report determination. There's a little bit of discrepancy on what statement, which is.
Okay. All right, I'll recall you shortly. Mr. Manning, who are you ready on?
Judge, ready on several resets, Miss Miles, in the first one.
Lanaria Miles, CR 223839.
Judge, Miss Miles, we requested an additional pretrial last time to go over the videos. Last week, we did go over the videos via Zoom, but unfortunately, the audio was not able to be played through to request, and I've talked to the state about getting a second pretrial to go over those videos with my client.
Dave.
That's my question.
All right, so Mr. Manning, you're requesting an additional pretrial.
That's correct, Judge.
I have August 9th, 11th, 23rd.
Judge, if we may, we could do the 11th.
11th.
Yes, Judge.
All right, court recess, Ms. Miles, for August 11th at 9 a.m. Ms. Miles, also show that you're delinquent on your pretrial financial obligations, $120. Can you pay that today? Can. Once you sign and get the yellow card, report to these officers and make that payment. You ready on Michael Lobb?
Yes, Judge.
Michael Edward Lobb, CR 2269. Mr. Lobb is set for docket call.
Yes, Judge. At this point in time, I have not had an opportunity to go over the discovery with Mr. Lobb. I believe we have some videos that are waiting to be produced. And so we request an additional opportunity to go over that.
So that we're on docket call today. Have we already passed pretrial? I thought we were past all the discovery issues.
Judge, I believe, and I'm trying to remember, I think I might have gotten subbed in. I'm unsure as to how we got to docket call, but Judge, I know I have not had, Mr. Law wasn't in jail, and so I was unable to view those videos in jail with him. And so I would just request an opportunity to go over that once he gets out.
Any objections?
No, Your Honor, Mr. Manning let me know on the 11th that he was trying to get Mr. Lobb in to watch Discovery. So that's
August 11th.
Yes, Judge.
Right, court sets Mr. Lobb for docket call on August 11th, 9 a.m. Mr. Lobb, once you sign and get the yellow copy, then I'm going to order you to go down to the end of the hall on the left, meet with the court compliance officer. I show you're delinquent over $1,500 on a former felony case. That's going to result in a warrant for your arrest.
No, I tried to pay. They said I was overpaid when I went down last month or last time I came here. That was $50 a head.
So they gave you a $50 refund?
You know, they just told me that they would advise I didn't pay for a couple months. But
All I know is I've got a note that says you owe $1,507.31 on CR 1721.
yes, sir, I was
That's
under,
okay. Get your yellow copy, go down to the end of the hall, meet with the court compliance officer. And don't leave there until if she says you're overpaid, then you're good to go. If you owe money, then you need to pay.
yes, sir.
Okay. Ready on Brianna Potterworth,
Judge, that's gonna be a plea. We're waiting on paperwork.
Brittany Turner,
Judge, I believe this is gonna be a reset, but I need to speak to the state before we reset that.
Mr. Villarreal, Mr. Villarreal here. Hold on just a second, Ms. Turner. Is Sergio Arturo Villarreal here?
Judge, I've not been in contact with him. If I may have a moment to reach out to him.
All right,
Judge, I also have Mr.
LaJean,
Lejean and I believe Mr. Bird as well. I didn't hear his name called on today's docket.
Mr. Bird, I see Tammy Caldwell. Mr. LaJean. Or Whitey.
BYRD.
Yes, is Mr. Bird still in custody? I've got him on the 1:30 docket.
Okay, I had not received that information.
All right, this is cause number CR 21402, State versus John William LaJean, pretrial.
Yes, Judge. Same announcement as from the previous, we are waiting on GVD for the Legon case. I've already met with him and gone over the written discovery back when he was appointed on May 24th. This is our first pretrial setting. We were requesting additional pretrial to go over the discovery.
State. My court will set Mr. LaJean for additional pretrial on August 11th at 9 a.m.
Judge, if I may have a little bit longer, since this case is pretty early on, if we could bump that a little bit further out.
August 23rd.
Judge, I don't believe I'm available on the 23rd. If we needed to do 11th, I can try to make arrangements to get the DVDs picked up. I know that the DA's office is a little bit behind on getting some of those prepared due to the absence of one of their employees.
Next date after that is September 20th.
That'd be fine with the defense.
State.
No.
All right, court will set Mr. LaJean for September 20th at 9 a.m. Mr. LaJean, I show that you're delinquent $110 on your pretrial fees and that you failed to report in June.
Failed to report.
That's what it says.
I thought it reported. I can report. From my understanding.
Sign, get your yellow copy, come over here and have a seat, meet with the pretrial release officer. And we'll get to the bottom of that.
I believe that the all that I have right now, I'll get the paperwork done on Ms. Caldwell and Ms. Caldwell.
Thank you, sir. Spain, are you ready? Mr. Dean, you'll come back up, sir. All right, back on the record, CR 22-200, State versus Wayne Dillon Dean. Set for arraignment. Have you had an opportunity to go over the indictment with your client?
Yes, Your Honor, we have. The
Go ahead.
state provided us a copy. My client's name is spelled correctly and he understands the charges against him. And at this time, he enters the plea of not guilty and asks for either a pretrial reset or a docket.
All right, court will find that Mr. Dean has waived the formal requirements of arraignment. His name is spelled correctly in the indictment. Court will enter his plea of not guilty into the record. Are you available on September 20th or 22nd, Ms. Payne?
22nd in the morning would be fine.
All right, court sets Mr. Dean for pretrial hearing September 22nd at 9 a.m. Mr. Dean, I need you to do two things. One, there's going to be conditions of pretrial release. All right, so you were arrested and you posted bail in this case. And the court's going to impose upon you conditions of pretrial release, which means that there's going to be conditions you have to comply with to maintain your freedom during the pendency of the pretrial. That means you're going to have conditions of bond, basically, to say can't drink alcohol, can't do drugs, got to report, got to pay. All right. So once you sign to get the yellow copy, I want you to meet with the pretrial release officers over here. They'll give you more information. The other thing that I need you to do, it appears to me that you were probably arrested outside Van Zandt County. Is that right?
I was arrested inside Van Zandt
You
County.
were arrested inside Van Zandt County.
It was off Highway 20 at 12:55.
Okay. Well, for whatever reason, it's being told to me that they do not have a tracking number for your arrest, which means that they do not have your fingerprints reported to the state. They're required to do that. The sheriff's office is required to do that. So I'm going to have an order right here that's going to direct you to just go out to the sheriff's office, present them. We're going to give you a copy of this. You present it to them. They're going to just take you back, get your digital fingerprints and send you on your way.
Okay.
Okay, thank you. So I need you to do those two things, get the yellow copy, meet with pretrial services. They'll give you a copy of this. Then when you leave, go out to the sheriff's office, show them that, and they'll get you processed. Okay?
All right, thank you.
You're welcome.
Your Honor, that concludes my business before the court. May I be excused?
Yes, ma'am.
Thank you.
Mr. Rash, you ready?
Request, we reset.
Yeah, come on up. I gotta get your client pulled in so she can be involved in this hearing. Just one moment. You're pulling his client into a Zoom hearing. We're about to do that. Ms. Hampton, can you hear me? All right, Ms. Hampton, I need you to unmute your device. And then I need you to adjust your camera and where I can see you. All right, Ms. Hampton, can you see and hear me okay? All right. This is cause number CR 2390, State versus Hannah Marie Hampton. We're set for unsuccessful discharge on the pretrial intervention contract. Your announcement, Mr. Rash?
We would request a reset due to my defendant being unable to attend today.
Reset for what?
Reset for additional hearing. We have not yet had an opportunity to talk to the prosecution about the case.
Your Honor, we would just ask that it be set to the August contested docket. Mr. Rash and I can discuss potential resolutions in the meantime. September, no, Tuesdays. We don't know what month it is, Judge. August, please.
Mr. Rash, any objection to the court setting it for bench trial on August 25th?
Yes, Your Honor, I have a conflict that day. Is there another day besides the 25th?
Next date after that would be September 22nd. I'm sorry, no, that would be September 29th.
I can do September 29th.
State.
No objection, Your Honor.
All right, court's going to set Ms. Hampton for trial before the court on Thursday, September 29th. That will be at 9 a.m. And Ms. Hampton, this will be the only notice that you receive from the court. We will not mail you a notice. So September 29th at 9 a.m. You understand? Okay.
Yes.
All right, then anything further, Mr. Rash?
Patty did receive the medical records. We requested the additional records.
Say that again.
Patty did receive the additional medical records you needed.
Okay, so. Okay. All right. If nothing further, then we'll be adjourned.
Thank you, Your Honor.
All right, thank you, Ms. You're welcome, Ms. Hampton. You don't have to do anything. I'll remove you from the case.
Thank you, sir.
You're welcome. All right, Mr. Easton.
Just for your scheduling, I would anticipate that we would only require 15, maybe 20 minutes.
Okay, thanks, sir.
Judge, ready on reset on Miss Turner.
Brittany Turner, CR 21400. Ms. Turner is set for pretrial.
Yes, Judge, we are in negotiations with the state on a resolution for this case. We have provided them with some additional information, both in their case, and we provided some information from third-party source. Request that pretrial be reset on this case to the August 11th date.
Objection from the state.
No, Your Honor.
Was that pretrial or docket?
Pretrial, Judge.
Judge, this case also involves yes, inner workings that we're trying to work out. That's the reason for the delay.
All right, court will reset Ms. Turner then for August 11th at 9 a.m. Ms. Turner, I showed that you're delinquent on your pretrial financials. Show that you're delinquent $200. Can you make a payment on that today? How much can you pay today?
I'll go pay all of it.
You can pay all of it? Okay. All right. Then once you get the yellow copy, they come over here and meet with the officers and they'll give you that information. Morning, Mr. Ugler. Yeah, I think you're on mute there.
Sorry,
No problem, no problem. Hope you're feeling okay.
my legal assistant told me I look bad and sound worse.
Well, I'm gonna let her take lead on that, okay?
That works.
Well, she's here and she's done you a fine service. I have all the paperwork before me, and
Perfect.
Mr. Chadwick's present in court. He can see and hear you at this time. So you should be able to see him. If you can't, you may have to move left or right if you're on your cell phone device or something. You'll see Mr.
Got it.
Mr. Chadwick, raise your hand right there. Help Mr. Hugo. There you go. All right, this is cause number CR 1953, State of Texas versus John Michael Chadwick. Mr. Chadwick, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So help you God.
I do.
Okay, you may lower your hand. Just speak up loudly and clearly so everyone can hear you. My court reporter here is going to take down everything that we say, okay?
Yes, sir.
All right. Your name is John Michael Chadwick, is that correct?
Yes, sir.
And Mr. Chadwick, you're before the court today on a proposed plea agreement between you and the state on the charge of indecency with a child by exposure. Mr. Chadwick, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. James Ugler. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed for yourself and with Mr. Ugler's assistance that you do not understand?
No, sir.
Mr. Ugler, do you believe Mr. Chadwick to be competent today? Have you explained to him both the advantages and disadvantages of a deferred adjudication along with his legal rights in this case?
I have, Your Honor, and I have no evidence to present to the court regarding any issues to competency now or sanity at the time of the commission of the offense.
All right. Thank you, Mr. Ugler. All right. Court finds that Mr. Chadwick was originally indicted with a second-degree felony offense of sexual assault of a child. The plea would be to a lesser included offense of indecency with a child by exposure. Proposed plea agreement is for the court to defer a finding of guilt and place Mr. Chadwick on 10 years community supervision with a $3,000 fine plus court costs. Is that your understanding of the plea, Mr. Chadwick?
Yes, sir.
Yours is your understanding as well, Mr. Ugler?
It is.
All right, Mr. Chadwick, a third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
If the court approves this plea agreement today and places you on deferred adjudication, if during the period of your community supervision, you violate a single term of the conditions of community supervision, then the state could file a motion to adjudicate your guilt. That means a motion to convict you of this offense. And the state could ask the court to revoke your community supervision. And if the court finds that you have violated your community supervision and the court does revoke your community supervision, the court could assess punishment anywhere within that legal range from 2 years up to 10 years in prison. Do you understand that?
Yes, sir.
Understanding the full range of punishment, understanding the plea agreement in this case, do you still wish to go forward?
Yes, sir.
All right. This time, Mr. Chadwick, the court will ask you, how do you plead to indecency with a child by exposure?
Guilty. Your Honor.
Mr. Chadwick, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Ugler, any objection to the state's evidence?
No objection to states one as Mark Knopford.
All right, states one, stipulation of evidence is admitted and the court does take judicial notice of Mr. Chadwick's judicial confession. Anything further from the state, and will the state touch upon victim compliance?
Yes, Your Honor. The state has given Mr. Chadwick a copy of the Chapter 62 warnings. Also, in regards to victim compliance, there is a victim impact statement on file that has been forwarded to the court. We would ask you at this time to review that before pronouncing sentence. Our victim is aware of the plea, is in agreement with the plea, but does not wish to be present or allocute.
Thank you, Ms. Heisel. Anything further from the defense, Mr. Ugler?
Your Honor, we do expect that Mr. Chadwick is going to be losing his residence in the very near future, because of the registration requirement. His plan is for him to move to the state of Georgia, where he is from. He has family there. He's already got an address there. So what we're asking for, and the state is aware of this, spoke with Ms. Curry about this over the last few days. We're asking for him reporting in person in Van Zant today, and then quarterly after that. Let him report the other month's mail, electronic mail, whatever the probation department has set up. We know it'll take some time with him not being a resident in Georgia yet for this to go through interstate compact. And I would point out to the court, he's been fully compliant. He has shown up at probably 24, docket calls here in the court. He lives currently in the Segoville area, and he has had no problem complying. So we're asking for this accommodation. It's my understanding the state does not object to that.
I think there's some confusion on where Mr. Chadwick was going to be living, because I understand that there's an issue with transferring him to Georgia. He's not already a resident there. Is that correct, Ms. Burns? Can you tell me what it is the probation department would need before the court could entertain or grant that?
Have to get in contact with Georgia.
Does Georgia have to pre-approve him? Mr. Hugler, Ms. Burns said that the state of Georgia, under the interstate compact, could take up to 45 days. They would have to visit Mr. Chadwick in Georgia, verify his residence, verify his occupation, his job, things of that nature. So I'm not sure that we'd be able to do that. So what we're gonna have to do, I think, is just go ahead and place Mr. Chadwick on community supervision here until he can satisfy the requirements under the ICP.
Well, and I understand there's going to be a delay, and 45 is actually shorter than I thought it would be. What I'm asking for is that the court allow him to report to probation here from Georgia while he is going through that process, so that he doesn't have to come back from Georgia every month to Van Zant County to report in person.
Ms. Heisel is talking with Ms. Burns at this time.
Oh, so they go out and see where he's gonna live, when he's gonna work. If he's there, that's. Mr. Hugler, can you hear me?
Yes.
Okay, I just want to make sure. Ms. Burns is telling me that under interstate compact that he can't move to Georgia until Georgia pre-approves him. So he would have to disclose to them where he's going to live, where he's going to work, all of those things before he makes the actual move.
That we can do. I think he's got the address with him today. Okay, we'll work this out.
So it means he'll be on probation here, reporting here, in person here, until he gets pre-approved for the transfer.
Right.
So, Mr. Hugler, do we need to resolve this case? Do you need to talk with Mr. Chadwick about this, or?
No, we're good.
Okay. All right, court's going to review the evidence briefly as possible. Just 1 moment. All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Mr. Chadwick of this offense. The court will follow the plea agreement reached between the defendant and the state upon the state's recommendation to the court. Court hereby defers a finding of guilt for John Michael Chadwick on the third-degree felony offense of indecency with a child by exposure. Court places him on community supervision for 10 years, orders him to pay a $3,000 fine, $290 court cost, and $2,545 reimbursement fees. Court also finds that this offense has been prosecuted under Chapter 62 of the Texas Code of Criminal Procedure and finds that sex offender admonishments are required. And sex offender registration is required. The court finds that Mr. Chadwick has been provided with a copy of Chapter 62 as required by the code. All right, Mr. Chadwick, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward here, Deputy McLeish, take your fingerprint, and after that time, we'll talk with the probation officer. It's really
No problem.
board too, so a lot of times these things happen, and we just have to reset. So,
It's one not to get sick. He didn't listen.
well, you know, he can hear everything you're saying right there. Hey, he needs to listen to you more often.
I know.
All right, thank you, Gabby.
Thank
Appreciate it.
you.
Get to
Have
feeling
a
better.
great day, Judge. Thank you.
Have a good day. Get to feeling better. Mr. Domin, are you ready? Sure. Lonnie Richardson, CR 21-404-405.
Yeah, Mr. Richardson, I just spoke with him on the phone. He had a work training that he was doing. It went about a day late. I anticipated him being here yesterday, but he said he'll be here probably by 11:30. I asked the court to hold off on holding the bond insufficient. I probably should have requested a continuance, but I thought that he would be back in time. It was cutting it a little late. So
Okay, I'll recall it at 11:30.
thank you, Your Honor. Do you want me to stick around and wait for him to get here or?
Yes, sir.
All right,
Yeah, otherwise I can't, you can't make an announcement without you.
I understand, Your Honor. Thank you.
Christopher Goins. All right, Mr. Rogers, can you see and hear me?
Yes, Your Honor.
All right, this is cause number CR 22-179, State versus Christopher Jamarquise Goins, and we're set for arraignment today. Mr. Rogers, have you had an opportunity to go over the indictment with your client?
Yes, Your Honor.
All right, are you ready to proceed for arraignment?
Yes, Your Honor.
Go ahead.
We'll waive formal arraignment, plead not guilty to all charges.
Is his name spelled correctly in the indictment?
Yes, Your Honor.
Does he understand the nature of the charge and the range of punishment?
Yes, Your Honor.
All right, court will find that Mr. Goins has waived the formal requirements of arraignment. Court will find his name is spelled correctly in the indictment, and the court will enter his plea of not guilty into the record. The court will set this matter for pretrial hearing. Mr. Goins, do you have your calendar available? Are you available on September? I'm sorry, Mr. Rogers, do you, are you having any availability on September 20th or 22nd trial hearing?
Give me 1 second. September 20th is fine with me.
Okay, all right, court sets Mr. Goins in for pretrial hearing September 20th. That will be at 9 a.m. And so, Mr. Rogers, that will be the statutory time that you got to file any contested pretrial motions, motion to quash, motion to suppress, things of that nature needs to be filed in accordance with the code at least 7 days prior to that date. Okay.
Yes, Your Honor.
And then if there are no contested pretrial days, then the court's next setting would be for docket call. And that would give you and the state an opportunity to finalize any kind of negotiations, if any will be had. Okay.
That is agreeable.
All right. Thank you, Mr. Rogers. I appreciate you, and you are free to go.
Thank you, Your Honor.
All right. And so I'm also, Mr. Rogers, before you go, I am going to have Mr. Goins sign his conditions of pretrial release. Could be conditions that are attached to his bond in this case. Okay. That's going to be
Okay.
report, drug test, things of that nature. And so he'll have a copy of that today.
Okay, thank you.
All right. All right, Mr. Goins, if you'll step over here with Ms. Burns, she'll give you more information. We're gonna have conditions of pretrial release for you to abide by. Okay, if you have any questions, they can give you answers, and then also you can speak with your attorney. Okay. All right,
Thank you, Your Honor.
You're welcome. Travis, you ready?
Yes, Your Honor.
Who are you ready on?
Call Mr.
Jason Bearden, CR 21-278. All right, Mr. Bearden is set for plea today. All right, Mr. Bearden, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right. Stand down. Your name is Jason Kobe Bearden.
Yes, sir.
And Mr. Bearden, are you a United States citizen?
Yes, sir.
Do you read, write, speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Depression.
Are you currently on any type of medication or undergoing treatment for your depression?
Yes, sir.
Do you feel like your treatment or medications giving you the ability to have rational thought and understanding of the proceeding as they are occurring today?
Very much so, sir.
In this case, also you are represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Like you had enough time to talk with him about your case and have all of your legal questions answered?
And that's affirmative, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir. It's all clear.
And I see that the proposed plea agreement is that you're going to plead guilty to the state jail felony charge of possession of a controlled substance of penalty group 1 less than 1 gram. The state's recommending that the court defer a finding of guilt, place you on community supervision for 2 years. In addition, you would have to pay court costs and reimbursement fees and restitution in this case. Is that your understanding of the plea agreement?
Yes, sir.
You've read over all of the conditions of community supervision.
Yes, sir.
And you know what's, if the court approves this and places you on that agreement, you understand what's expected and required of you.
That's affirmative, sir.
Mr. Adams, do you believe Mr. Bearden to be competent today? And have you explained to him the advantages and disadvantages of a deferred adjudication?
Yes, Your Honor. I believe that Mr. Bearden is legally, mentally competent. We have talked about the pros and cons of deferred adjudication probation versus straight probation. I believe this is a mandatory probation case. I might be wrong. Nope, Mr. Woodwike is affirming that I'm correct. But yes, Mr. Bearden and I have talked about the benefits and the drawbacks for deferred adjudication probation.
Mr. Bearden, the range of punishment for a state jail felony such as this, if convicted and sentenced, is a minimum 6 months to a maximum 2 years in a state jail prison, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
If the court places you on deferred community supervision and subsequently after a motion and hearing finds that you violate any of the terms of your community supervision, the court could adjudicate your guilt. That means convict you. The court could revoke your community supervision. The court could assess your punishment anywhere within that range of punishment, from the minimum to the maximum.
Yes, sir.
You understand all these things?
That's affirmative.
Understanding all of that, you still wish to go forward?
Yes, sir.
All right, Mr. Bearden, then how do you plead to possession of a controlled substance, penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime, sir, because you are guilty of committing that crime and for no
That
other reason?
That is a fact.
Anyone threaten, force, or pressure you to plead guilty today?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Adams, any objection to states 1?
No objection. It's marked and offered.
All right, states 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor. We rush to close.
All right, court will review the evidence. All right, the court finds that there is sufficient evidence to convict Mr. Bearden of this offense. The court will follow the plea agreement and recommendation of the state. Court hereby defers a finding of guilt for Jason Kobe Bearden. Places him on deferred community supervision for 2 years, orders him to pay $290 court cost, $535 reimbursement fees, and $180 restitution. Mr. Bearden, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. If you have a drug problem, now's the time to get help for Mr. Bearden.
I'm good. Your Honor, if I may address that briefly, Mr.
Yes, sir.
Bearden.
Go ahead.
Mr. Bearden has been working with the Salvation Army and the VA hospital and a joint program that they have there in Dallas County. He is participating in an employment program with them right now. He has completed an inpatient chemical addiction program prior to today's date. As you may have discerned, Mr. Bearden is a veteran, and it is through the Veterans Administration that he's been able to address his issue that brought us here today. So I think he's going to do just fine.
That's great. Court enjoys hearing that. Let's hope that you maintain your sobriety and apply the things that you learned in your program and get on probation and do what you're supposed to do. And then you can have this court out of your life. That's right. All right. Mr. Bearden, come on up here with Deputy McLeish. She's going to take your fingerprint. Kenneth Nash, CR 2271. All right, Mr. Nash is set for pretrial.
Yes, Your Honor. On behalf of Mr. Nash, I believe I have received all the discovery materials from the district attorney's office. From what I can see in the discovery portal, I'm not aware in reviewing that of anything that I'm missing. I do not have any pretrial matters to bring up with the court today. And we would ask the court to set us for docket call. We anticipate this is going to be resolved in a jury trial.
All right, court will set Mr. Nash for docket call to allow the defendant in the state to engage in plea negotiations if any are going to be had. We'll set this matter. Are you available? Do you know when you're coming back, Mr. Adams? That would be convenient for your schedule. I've got dates in August. I've got August 11th, 23rd.
I think I'm here on August the 11th, morning time.
You think that's enough time for you?
Yes.
I don't want to shortchange you. Okay.
No, I think I can live with that.
All right, court will set Mr. Nash then for docket call on August 11th. That will be at 9 a.m. Mr. Nash, I show that you are delinquent $180 on your pretrial obligations. Can you pay that today?
I did that this morning.
You paid that this morning? Okay, thank you, sir. Mr. Johnson, step up to these podiums right here. This is cause number CR 2393, State versus Jatari and Johnson. Mr. Johnson, set for arraignment today. I believe that I've reset your case to allow you to hire an attorney. Can you give me an update on whether or not you retained an attorney?
I just need just like a few more weeks, cause I had been behind on bills and stuff, and I ain't had a whole 2,000 for them,
How much do you have saved up now?
1,200.
So if I give you at least 2 weeks, you believe that you can get the remaining money that you need to hire an attorney?
Could you give me like 3, cause I had to pay rent on the first, and my rent $975, so.
So what I'm gonna do, Mr. Johnson, I'm gonna reset you to August 23rd. So that's more than 3 weeks. All right, so I expect if I'm gonna extend that to you, then I expect you to finish your business, hire that attorney, bring them back so we can progress with your case, okay?
Yes, sir.
All right, Deputy McLeish is gonna have you sign this notice of appearance.
Judge, I'm sorry. What day was it?
8/23.
I had some. It was my side of the car, but we know that I had on the foot. Okay. All right, thanks.
Dwight, are you ready? Ready as I am. Emily Gayton, CR 22-101-102. Is this for Mr. White? It has his name on. Is that for you? That's All right, Ms. Gayton, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may lower your hand. Make sure you speak up so I can hear you. So my court reporter can also take down everything that's spoken today. All right, Ms. Gayton, your name is Emily Grace Gayton, is that correct?
Yes, sir.
And Ms. Gayton, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes.
Is there anything about this paperwork that you've read over and signed that you do not understand? Mr. White, do you believe Ms. Gayton to be competent today? Have you explained to her the advantages, disadvantages of a deferred plea in addition to her rights in this case?
Your Honor, I believe Ms. Gayton is mentally competent, that she understands the proceedings that are pending against her. Well, as I have explained to her the advantages and disadvantages of a deferred case, when most notably if she completes it. Case will be dismissed, however, the show is suppressed from the record and she violates the term of petition. The court simply just hold the hearing. determine whether or not she did violate the state proof. About hundreds of evidence that she did in fact violate her probation, would have the entire range of punishment, which in this case, which is a state jail of up to 2 years and a $10,000 fine. I'm satisfied that she understands what she's doing in regards to her education part. And for her rights go, she raised those rights.
Thank you, Mr. White. Ms. Gate, did you hear everything that Mr. White said?
Yes.
Understand all of that? Ms. Gayton, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. That does carry a range of punishment of not less than 6 months in prison, up to a maximum 2 years in prison, a state jail prison, and also an optional fine not to exceed $10,000. Do you understand that full range of punishment? Do you understand if the court approves this plea and places you on 5 years of deferred community supervision, that if you violate any of the terms and conditions of your community supervision, the court, as Mr. White said, could conduct a hearing, and upon proof being given to the court that you have violated, the court could adjudicate your guilt. That means convict you of this offense. The court could revoke that community supervision and assess your punishment anywhere between 180 days, 6 months in prison, up to a maximum of 2 years. You understand that? Understanding all of that, you still wish to go forward? All right, Ms. Gate, how do you plead to abandoning or endangering a child with criminal negligence? Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason? Has anyone threatened, forced, or pressured you to plead guilty? All right, court accepts the defendant's plea of guilt. Mr. White, any objection to states one?
No objection.
States one is admitted, stipulation of evidence. The court does take judicial notice of Ms. Gate's judicial confession. Any further from the state? Defense.
No, sir.
All right, court will review the evidence briefly. All right, the court's reviewed the evidence. Court does find sufficient evidence to convict Ms. Gayton of this offense. Court will follow the plea agreement based on the recommendation from the state. Court hereby defers the finding of guilt, places Ms. Gayton on 5 years community supervision, orders her to pay a $2,500 fine. Court will dismiss cause number CR 22102. Section 1245 of the Texas Penal Code. Skaten, do you know how lucky you are? Do you really? Have you thought about it? Thought about that car could have been, you leave your kids in the car unattended. Somebody steals your car, kills your kids, leaves your kids somewhere. They die. Can you imagine having to live with yourself the rest of your life? 2 small kids in your car. They deserve better than that, right? The state, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with a deputy. And then I want you to step over here and speak with the probation officers, and they'll give you additional information about the next step. Trent Gonzalez, CR 22-135. All right, Mr. Gonzalez, if you'll raise your right hand, sir. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you put your hand down. Mr. Gonzalez, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork you've read and signed today that you do not understand?
I understand it all.
Mr. White, do you believe that Mr. Gonzalez is competent today and that he understands what he's entering into in this pretrial intervention contract?
Your Honor, I'm satisfied that this speedy trial waiver. Also a notation of what your right. I think is the most important one is waiver of the jury trial. Execute stipulation of evidence, explain to him the consequences of doing that as in regards to this intervention contract.
Thank you, Mr. White. To that point of waiver of jury trial, Mr. Gonzalez, you understand that you have the right to have your case tried before a jury of your peers?
Yes, sir.
That's an absolute right that you have that cannot be taken away from you. However, you can waive that right if you do so intentionally, knowingly, and voluntarily of your own free will. And is that what you're doing in this case?
Yes, sir.
You've considered the fact that once you waive your right to a jury trial, that that right will not be restored to you?
Yes, sir.
And you understand that as you stand there right now, you have the right to require the state to prove its case beyond a reasonable doubt in front of that jury. And during that jury trial, you have the right to confront the state's witnesses, to cross-examine the witnesses and confront all the evidence in front of that jury. You understand that?
Yes, sir.
You understand by waiving that today, you're waiving those rights as well.
Yes, sir.
All right, court will find that Mr. Gonzalez has been admonished regarding the waiver of his right to a jury trial. Court will find that he has entered into this waiver intentionally, knowingly, voluntarily. Court also finds that Mr. White has joined in with his client, and the state has waived its right to a jury trial in this matter as well. Court also finds that Mr. Gonzalez has waived his right to speedy trial and limited waiver of expunction. Court will approve the pretrial intervention contract and will place Mr. Gonzalez in this program for a period of 2 years on the charge of possession of a controlled substance, affiliate group 2, less than 1 gram. Court will find that Mr. Gonzalez has stipulated to the evidence attached to the contract. Court will take judicial notice of the defendant's judicial confession as contained there. All right, Mr. Gonzalez, I have you come forward and meet with the probation officers, and they'll give you information about the next step.
Yeah. Your Honor, one more thing, correct. There's a $500 fee on this that will be paid from my office. I don't check in my office, so I'm gonna take it over there.
Okay, I think Mr. Woodwhite charges $25 late fee, but
Hopefully it won't bounce.
all right, thank you, Mr. White. Stephen Slayton, CR 2194. All right, Mr. Slayton is set for plea today. Mr. Slayton, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may lower your hand. Your name is Stephen Kyle Slayton. Mr. Slayton, are you a United States citizen?
Yes, sir.
You also read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are also represented by Mr. White. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. White, do you believe Mr. Slayton to be competent, and have you explained to him his legal rights in regards to this case and his plea agreement today?
Your Honor, I believe Mr. Slayton is competent, that he understands the proceedings and the duties. Also explained to him right to appeal, waive those rights.
Thank you, Mr. White. Mr. Slayton, you are charged by indictment with a third-degree felony offense of theft of property greater than or equal to $30,000, but less than $150,000. That does carry a range of punishment if convicted and sentenced to a minimum 2 years up to a maximum 10 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
Plea agreement in this case appears to be that you would plead guilty to that charge in exchange for the state's recommendation that your punishment be assessed at the maximum 10 years confinement in the Texas Department of Criminal Justice, with the state recommending that to the court that that sentence be suspended today, that you be placed on community supervision or probation for a period of 5 years. And as conditions of your community supervision, you would have to pay restitution of $6,823.24, which would be paid joint and several with cause number CR 20156, the state versus Robert Dixon. In addition, you would also have to pay your court costs and reimbursement fees in this case. Is that your understanding of the plea agreement?
Yes, sir.
That's what you're asking the court to approve today.
Yes, sir.
All right, Mr. Slayton, the court will ask you, how do you plead to that charge?
Yeah.
You plead guilty to that charge because you are guilty of committing that crime.
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
Court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence and stipulation?
No objection, Your Honor.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. The state is in compliance with victim notification. As you will see, the judgment includes restitution. That restitution amount is to 2 different victims, both of whom we are in contact with.
Thank you, Mr. White.
If I, and I know it's noted in the judgment, but it's also several.
All right, the court's reviewed the evidence. I do find sufficient evidence to convict Clayton of this offense. Court will follow the plea agreement in this case and the recommendations of the state. Court hereby convicts Stephen Kyle Slayton of the third-degree felony offense of theft of property, $30,000 to $150,000, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice, suspends that sentence, places him on community supervision for 5 years, orders him to pay restitution of $6,823.24. Court orders that restitution to be paid joint and several with Robert Dixon and cause number CR 2156. In addition, the court orders Mr. Slayton to pay court costs of $290 and reimbursement fees of $160. Mr. Slayton, have you been on probation before?
Yes, sir.
You know what's required and expected of you?
Yes, sir.
When you violate any of your conditions of community supervision, what could happen?
Go to prison.
For how long?
Or, the maximum, I guess, for that, right?
Well, sentence has already been imposed today. What sentence has the court imposed on you today?
10 years.
10 years. So when you violate, you go to prison for 10 years.
Sure.
Okay. All right, Mr. Slayton, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. We'll have you step forward to be fingerprinted with Deputy McLeish, and you will report to the probation officers over here. Dalton Thompson. All right, Mr. Thompson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may lower your hand. Your name is Dalton Garrett Thompson, is that right?
Yes, sir.
Mr. Thompson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar depression.
Are you currently on treatment or medication for those? Do you feel like you have a rational understanding of the proceedings as they are occurring today? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
Yes, sir.
Mr. White, do you believe Mr. Thompson to be competent today? And have you seen any evidence of his mental health that caused you concern?
Your Honor, I have no concerns and I'm satisfied. Mr. Thompson did that he understands proceedings of the game here today and the nature of the agreement that we're trying to enter into. We've executed some waivers. I believe he's executed those waivers knowingly, intelligently, and voluntarily.
All right, Mr. Thompson, court finds that you were indicted with a third-degree felony offense of evading arrest or detention with a vehicle. However, the plea agreement for the court today is that you would plead guilty to a lesser included offense of fleeing from a police officer with imminent danger or serious bodily injury, a Class A misdemeanor. And I see the agreement is that you would plead guilty to that. The state would recommend that you be convicted of that offense, that your sentence be assessed at the maximum 1 year in the county jail, with it being suspended and you being placed on probation for 2 years with a $2,000 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
That's what you're asking the court to approve?
Yes, sir.
All right, Mr. Thompson, how do you plead to fleeing from a police officer with imminent danger or serious bodily injury?
Guilty.
You pleading guilty to that crime because you are guilty of committing that crime? Does anyone threaten, force, or pressure you to plead guilty? Court accepts the defendant's plea of guilt. Mr. White, any objection to state's evidence?
Okay.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, you're not moving.
From the defense?
Nothing further.
All right, court finds that there's sufficient evidence to convict Mr. Thompson of this offense. Court will follow the plea agreement. Court hereby convicts Dalton Garrett Thompson of fleeing from a police officer, class A misdemeanor. Court assesses his punishment at 1 year confinement in the Van Zandt County Jail. The court suspends that sentence, places him on 2 years community supervision, orders him to pay a $2,000 fine, $270 court cost, and $35 reimbursement. All right, Mr. Thompson hereby remanded to the custody of the Van Zandt County Community Supervision and Correction Department so they can carry out the terms and conditions of the sentence. We'll have you step forward to be fingerprinted and go report to the probation officer. That's all. Yes, sir. CR 21-157. Mr. Anderson, you are charged by indictment with a third-degree felony offense of possession of a controlled substance. that does carry a range of punishment of not less than 2 years or more than 10 years in prison if convicted and sentenced. I see that you've requested a court-appointed attorney. The court has reviewed the paperwork, and based on your assets and your income and your expenses, you do not meet the financial requirements to receive court-appointed counsel, meaning you're not deemed indigent. So what I can do is I can give you an option. I can reset your case and give you time to hire an attorney, or you can represent yourself, which I would not advise. If I reset your case, gave you time to hire an attorney, believe you can get that done?
Yes, sir.
Okay, I'm gonna reset you. I'll set you out a little bit longer than 30 days to give you time.
I appreciate you.
Okay, so I'm gonna reset you until September 20th. That would be at 9 a.m. Okay,
Yes, sir.
so what I expect is you'll go out and you'll hire an attorney, and if not, then I expect you to come back and have a really long report for me of who you've talked to, how much they want, how much you've saved, things of that nature. Okay. Ready? Not yet. CR 1964 state versus Anitra Janae Porter. Ms. Porter, you're currently on community supervision, right? And you're asking the court, you have to say yes or no out loud so she can type it. You're on probation. And Ms. Porter, you're asking the court to extend your probation period. Right now, you're set to expire here in about a week. But you're asking the court to extend you for an additional year to July 27th of 2023. Why do we need to extend your probation? I'm sorry, you're going to speak up. So
Like money for it and stuff, and like since my correction, but I haven't been able to get around.
So you're lacking community service and money. If I extend this, do you believe that that will give you enough time to get your money together and get your community service done? This is what you're asking the court to do this. No one's telling you that you have to have it extended.
Yes, sir.
All right, court will approve the amendment to the conditions of community supervision. The court will extend the period for an additional 1 year, beginning July 28th of 2022. 27th of 2022. So you can go with Officer Ventura here. It should be a copy of that. Okay. Just 1 second. All right, Mr. Double, if y'all step up, this is cause number CR 2160. We're set for pretrial. Go ahead, Mr. Schuman.
We have, may I address the court?
Go ahead.
And we have received the discovery. I've had it for some time. I've been through it. I'm not completely satisfied that I know it all yet, but I need to get with Mr. Beverly. What I'd like to do, if the court would allow us, is set this over for a docket call in September. The state tells me they wouldn't oppose that. Would like to do that.
That's correct. I proposed this one this week, third, Mr. Schuman has conflicts, so we don't oppose early in September.
All right, court will set, well, the only thing I have in September, the earliest I have is September 20th. So you're available September 20th.
I'll make myself available, Your Honor.
All right, court sets Mr. Beverly then for docket call September 20th. That'll be at 9 a.m. Mr. Schuman, remind me again why Mr. Beverly was late today.
Your Honor, he had car trouble, and then his ride had car trouble. And I apologize.
All right, Mr. Beverly, the court's going to place you on conditions of pretrial release. All right, so after you sign and get the yellow copy, over here, meet with the pretrial release officers, the bail that you posted in this case be out at this time. I'm gonna have conditions on that, meaning that you're gonna have to report a drug test. If you violate any of these conditions, the court could find your bail to be insufficient and put you back in jail. So once you get the yellow copy, come over here and meet with Officer Burns, and she'll give you more information about that. All right. Yes, thank you, sir. Appreciate it.
This was the attachments. Spot on, so that there's something they want on this call.
Ms. Podorf, CR 2243. All right. Ms. Potter, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, you may put your hand down. Your name is Brianna Nicole Podorf, is that correct?
Yes, sir.
And Ms. Podorf, are you a United States citizen?
Yes, sir.
You read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to discuss the case with him and have all of your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Manning, do you believe Ms. Potter to be competent today?
She is, Judge.
And have you explained to her her rights as they pertain to this case?
I do. I have, Judge, and she understands those.
All right, Ms. Potter, if I see that you were originally charged by indictment with a third-degree felony offense of injury to an elderly individual. However, the plea agreement before the court today appears to be that you would plead guilty to a lesser included charge of assault causes bodily injury. That punishment would be recommended at 5 days confinement in the county jail, with you receiving credit for time served. Mr. Eastland, Mr. Eastland, Mr. Eastland. Can I ask you guys to step outside? Because I'm not sure she can hear if you are talking. It's okay. Ms. Potter, do you understand that the recommended punishment is for your sentence to be assessed at 5 days in the county jail, with you receiving credit for time served, with you paying a $1,000 fine, court costs, and reimbursement fees?
Yes, sir.
And are you paying any of your financial costs today?
Yes, sir.
What are you paying today?
200.
200. And how are you going to pay the rest?
Judge, we're going to be asked that she put on a payment plan. She is right now caring for her mother, unable to work and care for her mother. Her mother's hospitalized. And so we would ask that she be put on a payment plan, explain the process of the payment plan, as well as the seriousness of the payment plan before this court. And I believe she should be able to be successful on that.
How much do you think you will be able to pay a month, Ms. Potter?
About 15 to 100.
50 to 100?
Yes, sir.
And you understand that if you do not comply with that payment plan, you understand the court will issue a warrant for your arrest. We'll start this process over.
Yes, sir.
All right, then Ms. Potter, let me ask you, the range of punishment, let me inform you, the range of punishment for Class A misdemeanor is maximum confinement in county jail for up to 1 year and a $4,000 fine. I see here that this plea agreement would fit within that range of punishment. So understanding the range of punishment, understanding the plea agreement, you still wish to go forward?
Yes, sir.
So Ms. Potter, how do you plead to assault causes bodily injury?
Guilty.
Are you pleading guilty to that charge because you are guilty of committing that crime? You have to say it out loud so she.
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection, states one.
State's one is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, yes, the state is compliant to victim notification. However, we have not received any response from the district.
Anything further from the defense?
For defense.
All right, the court's reviewed the evidence. I find there's sufficient evidence to convict Ms. Potter of this offense. Court will follow the plea agreement in this case. Court hereby convicts Brandon Nicole Potter of assault causes bodily injury, class A misdemeanor. Assesses her punishment at 5 days in the Van Zandt County Jail. The court awards her credit for 5 days of time served. Court orders her to pay a $1,000 fine, $270 court cost, $535 reimbursement. Ms. Potter, you're hereby remanded to the custody of Van Zandt County Sheriff so you can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy McLeish. After which I want you to get a copy and then go down to the end of the hall to the compliance officer. Make arrangements to, and I want the 200 paid today, and then I want you to set up the payment plan. Come on up here and get fingerprinted. Tammy Lynn Caldwell, CR 2290. Ms. Caldwell, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? Okay, may lower your hand, make sure you speak up loudly and clearly so my court reporter can hear you. Caldwell, are you a United States citizen? You read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you? Feel like you've had enough time to discuss the case with him and have all your legal questions answered? Is there anything about the paperwork that you read and signed today that you do not understand? Mr. Manning, do you believe Ms. Caldwell to be competent today, and have you explained to her this case with regards to her rights and consequences of her plea?
Judge, she is competent. I have explained her rights, and she is voluntarily and knowingly waiving those rights to go forward today.
Caldwell, you are charged by indictment with a state jail felony offense of driving while intoxicated with a child under 15 years of age. That does carry a range of punishment of not less than 6 months or more than 2 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment? I see the proposed plea agreement is that you would plead guilty to that charge. State is recommending 18 months confinement in state jail. Recommending to the court that that sentence be suspended, that you be placed on 2 years community supervision with a $1,000 fine plus restitution, court costs, and reimbursement fees. Is that your understanding, Ms. Caldwell, of the plea agreement? And that's what you want the court to approve today? All right, Ms. Caldwell, how do you plead to driving while intoxicated with a child under 15 years of age? Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today? My court will accept the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection, states one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Just briefly, Judge, for record purposes, because this offense does not involve alcohol, we requested a waiver of the intoxilizer under 42A, and just note to the court that's part of the conditions of probation. There is not intoxilizer for this offense.
Dave,
Judge, state understanding that Ms. Caldwell was involved in a CPS case that resulted from this, and she has not returned back due to good steps. We're going to give her the attorneys we're going to take the position. We don't believe she requires intoxilizer in her vehicle. We trust this court to check.
Mr. Manning, you've discussed with the court that the Code of Criminal Procedure doesn't appear to require the imposition of an interlock device on this type of offense. Is that correct?
That's correct, Judge.
All right, court's reviewed the evidence. I do find sufficient evidence to convict Ms. Caldwell of this offense. Court will follow the plea agreement in this case. Court hereby convicts Tammy Lynn Caldwell of driving while intoxicated with a child under 15 years of age. Court assesses her punishment at 18 months confinement in the State Jail Division of TDC. Court suspends that sentence, places her on 2 years community supervision, orders her to pay a $1,000 fine, $290 court cost, $60 restitution, orders her to reimburse Van Zandt County $535. Ms. Caldwell, why are you emotional?
When I was in my CPS case and we would go to court, I was crying. They made fun of me in my last court date because I was getting my kids back and I was still crying.
How long were you without your kids?
A year.
A year? Is that hard?
Yes.
Yeah, I could imagine it actually. I'm a dad and I have kids. I could imagine being away from them more than a few days. Very lucky though that you got arrested that night. You're very lucky that you only spent a year away from them. Could have been a lot worse. You could have been a lot worse. But you can look at this as a bad thing that you're on probation and you're having to go through this, or you can look at it as a blessing, for which I do, that you had a chance that someone's intervened in your life. You have a chance to get away from methamphetamine and you didn't lose your kids permanently. And or you didn't get in a car and drive away and kill themselves, kill you, kill someone else. So as you walk out of here today, yeah, you're on probation. You're convicted. You're convicted felon, but you got your 2 kids and you got your life and you have a future. So whatever you make of it's on you now. All right. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward, be fingerprinted with Deputy McLeish, and then you'll step over and meet with the probation officers. Yes, before we do that, just for the record, for Ms. Caldwell, the court does make a finding that the Code of Criminal Procedure does not appear to require as a mandatory condition of community supervision, the installation of the interlock device. And we will waive that for Ms. Caldwell at this time. Yes, sir. This says June 23rd. July 21st. We were here. There.
June 23rd is when the jury returned, so I'm sure that's why I'm saying that. It's 10 days. And that's what we did.
Mr. Piercefield, in your case, Ms. Chester is your attorney. So, Ms. Chester has recently given birth and she's unable to be here today, I believe. We haven't had any contact with her, so what I'm gonna do is I'm just gonna reset your case till August 11th. So I want you to try to call her office. Have you been in contact with her?
I have been recently.
on trying. So we're gonna have you sign and get your reset notice. Show that you're delinquent on your pretrial fees.
Yes, sir. I can make a payment.
How much can you pay?
$40.
Okay, so I want, you're delinquent 180, so you're gonna keep on.
Yes, sir. I just got back, full recovery from my broken leg, so I just started working again.
Okay, maybe, so what we're gonna do is we'll have you sign right here. Go ahead and do that. So the two things, I want you to meet with these officers, pretrial release officers. I want you to make a payment to them, but before you leave the courthouse, I also want you to go down to the end of the hall and meet the court compliance officer. You have an old case that you owe money on, and I'm afraid of warrants about the issue for that. So we need to make sure that you're paying on both of them. So meet with them first, with their instructions, go down and meet with Ms. LaPrada in the hall on the left.
Yes, sir.
Talk to her about your payment plan, make a payment on that one too.
Yes, sir.
All right, so we'll keep you out of jail. All right. I don't know if I took the docket call. Just what you put on there. Check the docket. That's okay. We just put 11. Yes, that's fine. Mr. Ibarra here earlier. You wrote, that's okay. I didn't. So Joshua Ibarra. Sperling's not here. Sperling wasn't here either, right?
Right.
I show that he has a warrant there. Yeah, I was just checking on Casey Chester's. Still talking. These are the names that I showed. Go ahead and call these names. First page, Michael Davis. Yes, sir. Second page, Jaime Murillo. Barrientos. Yes, sir. Jaime Murillo. So have Joshua Ibarra. Yes, sir. Eric Sperling. Actually, you don't need to call Eric Sperling. I believe that Eric Sperling has a warrant. Correct. Yes, sir. In this case. I'm gonna recall. Yes, sir. Yes, sir. Sergio Gabriel. Yes, sir. All right, this is cause number CR 22-175, State versus Kevin Collins. Mr. Collins is set for arraignment today. He's requested court-appointed attorney. The court has found Mr. Collins to be indigent today, has appointed the Honorable Jonathan Manning to represent Mr. Collins, and we're set for arraignment. Mr. Manning, are you ready for arraignment?
Yes, Judge. I've gone over the case with my client. He understands the charge against him. His name is spelled correctly, and this time he pleads not guilty. The request will be set for pretrial in this case.
All right, court will enter Mr. Collins' plea of not guilty into the record. We'll set this matter for pretrial September 20th. Tuesday, right?
Thursdays.
You want a Thursday, September 22nd.
Perfect.
And Mr. Collins will be required to sign his conditions of pretrial release today. I don't know if he's already done that. If not, Mr. Collins, after you get the yellow copy, you'll report to the pretrial officers. We'll have conditions of pretrial release. These are going to be conditions that you have to comply with so you can stay on bail in this case, okay? All right. So do you want to join? All right, this is cause number CR 2358, State of Texas versus Eric Gerardo Rodriguez Castro. Mr. Castro, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got.
Yes, Your Honor.
All right, put your hand down. All right, Mr. Castro, you appeared before this court and a jury trial was had in this matter in which you were charged by indictment with driving while intoxicated, third or more. The jury returned a verdict of guilty in this case, and this matter was set for sentencing before the court. You had elected the court to assess sentencing in your case. We were set today in the court ordered the preparation of a pre-sentence investigation report that was completed and provided to the court and to counsel. It's my understanding, though, that today you are wishing to enter into a negotiated agreement with the state with regards to sentencing. Is that correct?
Yes, sir.
And you're asking the court today to impose a sentence of 10 years confinement in the Texas Department of Criminal Justice Institutional Division, with that sentence being suspended today and you being placed on community supervision for a period of 5 years. In addition to that, a fine of $2,000 plus court costs of $290 and reimbursements of $55. Is that your understanding of your agreement with the state?
Yes, Your Honor.
This is the state's agreement as well.
Yes, Your Honor.
And you understand, Mr. Rodriguez, that as a part of this plea, you would also be waiving your right to appeal your case. You'd be waiving your right to appeal the issue of the guilty verdict and any error that may have occurred in that trial. You understand?
Yes, sir.
You're also waiving your right to appeal sentencing in this case, as long as the sentence is within the statutory range of punishment. You understand?
Yes, sir.
All right, and have you had enough time to discuss this decision with your attorney, Mr. Eastland?
Yes, sir.
Have you been satisfied with Mr. Eastland's representation of you?
Yes, sir.
Mr. Eastland, do you believe Mr. Rodriguez is competent to enter into this agreement today?
I do, Your Honor.
All right, Mr. Rodriguez, the court will find that you have been found guilty by a jury of your peers on the charge of driving while intoxicated, third or more. The court has already accepted the jury's verdict of guilty in that matter. The court hereby accepts a sentence agreement recommendation from the defense and the state. The court hereby imposes sentence at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence today and place you on community supervision for a period of 5 years. Order you to pay a $2,000 fine, $290 court cost, and $55 reimbursement fees. Court finds that you have intentionally, knowingly, and voluntarily waived your right to appeal in this case. Court also finds that under the Code of Criminal Procedure that Mr. Rodriguez is required to serve 10 days confinement in Advancing County Jail as a condition of his community supervision. In this case, the court finds that Mr. Rodriguez will serve the sentence, will serve the required days in jail as a condition of his community supervision on the dates and times outlined in Exhibit A of the special order for committing to jail. So, Mr. Rodriguez, when you do present yourself to the Advancing County Jail, you'll need to present yourself with this paperwork, the order, the dates and the times. In addition, you'll need to bring a photographic ID so that they know who you are. If you fail to bring one or the other, they're not going to let you in. They're going to notify the probation department that you didn't appear as ordered. Okay. Do you understand that?
Yes, Your Honor.
All right. In my opinion, Mr. Rodriguez, I think Mr. Eastland has done a fine job for you here today, reaching this agreement that's been extended by the state. This is your third DWI offense. Next stop any violation of your conditions of community supervision will land you in prison for 10 years. That's the sentence that's been imposed today. So won't be any coming back and negotiating for 2 or 3 or 4 or 5. It's going to be 10 years in prison. So if you have a problem with alcohol, I think that you do. I think you know that you do. Otherwise, you wouldn't have been through court 3 times on drinking and driving. I hope that you get that fixed while you're on probation. If there's something that you need to help you get that handled, then you need to tell your probation officer or find out if there's a resource or program that you can go to that'll help you. Doesn't do you any good to be sitting in prison, doesn't do society any good have you sitting in prison unless you can't stop drinking. Understand?
Yes, Your Honor.
All right, Mr. Rodriguez, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. And have you be fingerprinted with Deputy Police Sheriff and the probation officers will give you more information. All right. Here you go. Thank you for your patience.
Well, it has given me
All right, this is cause number CR 21-404-405, State versus Lonnie Jean Richardson, set for docket call today. Any announcements, Mr. Donovan?
Your Honor, we completed discovery yesterday and a new offer was extended yesterday, which I've relayed to my client. I'd asked the court to reset this for another docket call on September 22nd for my client to consider the offer and for us to review the rest of discovery.
Is the offer that he's received now significantly different than the offer that was there before?
I think that was the first time the offer was. Yeah, I think this is the first offer that was extended, Your Honor.
Number of documents. And you're asking for September? Why September?
I have conflicts. I checked the court with the August dates. I have conflicts on the August dates.
On the 9th, 11th, and 23rd?
Yes, on the 23rd, I have a conflict in Rains County. And that was when Watson was reset for. He was my client who was set for arraignment. We filed the waiver on earlier today. I'll probably have to try to get that one moved to September as well.
What do you have in Rains on the 23rd?
I have a plea on DWI.
What time is that?
It is at 9 a.m.
And we could set it on the 23rd and you just appear after Rains is only 20 minutes.
Right. Yeah,
Would that be fine? We'll just set it on the 23rd. I don't want to set it out 60 days.
I understand, Your Honor.
Let's set it 23rd and then I'll just mark that you'll be like a little bit late that day.
Okay.
And then, Mr. Richardson can come on at 9 o'clock and then just once you finish up there, then come on down and we'll address this. So we're going to set that for 8:23 at 9 a.m.
Sorry for the tardiness, Judge.
Mr. Dahman, he told me why you were late. I understand. So I appreciate the apology.
Thank you, Your Honor. Would you like me to pass it?
Yes, once you get the yellow copy, well, I don't need to sign it. So once it's all dated and signed and he gets the yellow, we get the white, then he'll be free to go.
Thank you, Your Honor. My excuse as well.
Yes, sir. Thank you.
Thank you, Judge.
You're welcome.
Yes.
Call the nice size and get out of here. All right, so the court has called the names Michael Davis, Jaime Murillo, Joshua Ibarra, Sergio Villarreal. Court called those at 9 a.m. They were not present. It's noon. They've still not made an appearance in the court. The court has had their name called by the bailiff loudly, distinctly 3 times in the courthouse with no response. Court hereby issues judgment nisi alias capias in each case. Court will stand in recess until the 1:30 docket. He already has a surrender principle, I believe. Yes, Mr. Gilbert actually missed court last time. I had it under advisement until today.
Y'all don't have anybody expected in here after lunch, correct?
Correct.